The Supreme Court ruled unanimously against the FBI, and now the Justice Department is trying to sidestep that ruling anyway. In a stunning legal maneuver, following a definitive 9-0 defeat at the nation's highest court, the Department of Justice is actively pursuing strategies in lower courts designed to bypass the explicit accountability framework established by the Supreme Court's recent unanimous judgment against the Federal Bureau of Investigation, raising profound questions about institutional resistance to judicial oversight and the enforcement of constitutional protections against federal overreach. Federal agents raided the wrong home, traumatized a family, lost 9-0 at the Supreme Court, and are still fighting to avoid responsibility. Despite the undisputed facts that federal agents mistakenly executed a no-knock raid on the home of an innocent family, deploying excessive force, causing significant trauma, and subsequently suffering an absolute loss at the Supreme Court, which confirmed the family's right to sue, the government continues its aggressive legal defense, prioritizing institutional self-preservation over acknowledging the catastrophic consequences of their agents' verified operational failure. This case could decide whether the federal government is ever accountable for violent mistakes made in your home. At its core, this ongoing litigation poses a foundational challenge to the principle of federal accountability, threatening to define whether the government can remain legally shielded when its agents commit violent, negligent errors during law enforcement operations executed inside private residences, thereby establishing a critical precedent that could either bolster or severely weaken citizens' ability to seek redress against the state. The Supreme Court drew a clear line on government immunity. Now, the DOJ is testing how far it can ignore it. The recent unanimous Supreme Court decision was intended to draw a bright, unmistakable line limiting the scope of qualified immunity for federal agents in specific circumstances. Yet the Justice Department's subsequent legal actions in lower jurisdictions appear to be a deliberate attempt to probe the limits of judicial authority, aggressively seeking loopholes to undermine the spirit and practical application of the High Court's directive. An innocent family had flashbangs thrown into their living room, and the government's defense is still, "We're immune." The shocking reality of this case centers on the fact that an innocent family endured the terrifying deployment of flashbang grenades and armed entry into their home by federal agents operating under a mistaken address, and despite the verifiable trauma and judicial rebukes, the government's sustained legal argument remains rooted in the absolute claim that their conduct, however egregious, is legally protected by sovereign immunity. A unanimous Supreme Court ruling was supposed to end this fight, but it didn't. Legal observers and the aggrieved family believed that the 9-0 decision from the Supreme Court, which clearly supported the family's right to proceed with their lawsuit, would finally put an end to the protracted legal battle, but the government's tenacious refusal to concede and their pivot to new procedural defenses demonstrates a fierce institutional determination to prolong the conflict, turning a clear judicial victory into an ongoing war of attrition. If the DOJ wins this argument, wrong house raids may effectively become untouchable under federal law. The critical danger presented by the Justice Department's revised legal strategy is the potential for a precedent wherein operational mistakes during raids, specifically those involving mistaken identities or addresses, could be redefined as policy choices or discretionary functions. A classification that would grant near total immunity under the Federal Tort Claims Act, rendering future victims of wrong house raids virtually powerless to sue. The FBI admits it hit the wrong house, yet the government insists that mistake is legally protected. In a truly remarkable display of legal maneuvering, the Federal Bureau of Investigation acknowledges the fundamental error that their agents forcibly entered and searched the incorrect residential property. But this factual admission does not translate into accountability, as the government's legal team continues to maintain that this documented and consequential mistake falls squarely within a realm of discretionary governmental conduct that is inherently shielded from legal challenge. This isn't just about one family in Georgia. It's about what happens when federal power gets the address wrong. While the genesis of this legal battle lies with a specific family in Georgia whose lives were violently upended, the implications extend far beyond a single jurisdiction, centering on the national question of what concrete legal recourse exists for any citizen when the immense power of federal law enforcement is mistakenly directed at the wrong target, underscoring the vital need for enforceable limits on state authority. The Supreme Court narrowed government immunity, and now the DOJ is asking a lower court to widen it again. Following the Supreme Court's definitive decision to narrow the application of qualified immunity in cases of egregious federal error, the Department of Justice has strategically returned to the lower courts, deploying novel arguments that effectively ask judges to interpret existing statutes in a way that would dramatically re-expand the government's immunity protections, directly challenging the spirit of the High Court's recent ruling. The question now before the courts is simple but dangerous. Can federal agents raid the wrong home and walk away? The immediate judicial dilemma confronting the appellate system is stark. Whether the law permits federal agents to execute warrants at demonstrably incorrect addresses, inflicting damage and trauma, and then simply utilize a shield of legal immunity to avoid any financial or systemic accountability, a ruling that would have dire consequences for public trust and constitutional rights across the country. After losing unanimously at the Supreme Court, the government is recycling arguments the court already rejected. In a sign of extreme institutional desperation, the legal team representing the government is reportedly attempting to reintroduce and reframe core arguments concerning the scope of discretionary functions, arguments that were fundamentally discredited and rejected by every justice on the Supreme Court in their unanimous opinion, forcing the lower judiciary to confront a deliberate attempt to subvert the established legal precedent. The DOJ says raiding the wrong house was discretion. The victims say it was negligence. The courts must decide. The central definitional dispute in this high-stakes case pits the Department of Justice's claim that the agent's actions, including the failure to verify the address, constituted protected discretionary judgment, against the victim's assertion that the blunder was nothing less than actionable negligence, placing the ultimate responsibility on the courts to determine which category of conduct applies to such a catastrophic operational failure. This case exposes how far federal agencies will go to avoid accountability, even after a historic loss. The protracted nature of this legal defense, sustained even after a historic, unanimous loss at the highest court in the land, offers a sobering window into the deeply ingrained institutional impulse of federal agencies to shield their personnel from civil liability, illuminating the profound lengths to which the government will go to protect its power structure rather than accept responsibility for verified harm. The Supreme Court said judgment alone doesn't equal immunity. Now the DOJ is betting the lower court won't enforce that. The Supreme Court explicitly clarified that simply exercising judgment, or making a judgment call, does not automatically confer legal immunity under federal law, but the current strategic pivot by the DOJ strongly suggests they are gambling that a lower appeals court will prove less rigorous in applying this newly established standard, offering them a second chance to evade the clear mandate of the highest court. A wrong house raid, guns drawn, flashbangs deployed, and the government still claims legal protection. The facts on the ground paint a horrifying picture. A completely innocent family was subjected to a paramilitary-style raid featuring drawn weapons and explosive flashbang devices inside their private home. Yet despite this extreme and verifiable error, the legal position of the federal government remains adamantly focused on maintaining an absolute claim to legal protection from any consequence. If this argument succeeds, nearly any law enforcement disaster could be rebranded as policy choice. A successful outcome for the Department of Justice in this current phase of litigation could establish a tremendously dangerous legal precedent, allowing almost any operational malfunction, oversight, or catastrophic error by federal law enforcement to be retroactively labeled as a discretionary policy choice, effectively neutralizing civil litigation and extinguishing the few remaining avenues for public accountability. The family says executing a warrant at the correct address isn't discretion, it's the bare minimum. From the perspective of the traumatized family, the required action of a federal agent tasked with serving a warrant is not a matter of high-level policy discretion, but rather the absolute, fundamental obligation to correctly identify the target location, arguing forcefully that simple. Verification of the address constitutes the minimum standard of professional conduct, not a protected policy decision. The DOJ's position could make immunity the rule, not the exception, for federal law enforcement mistakes. Should the Justice Department prevail with its expanded interpretation of discretionary function immunity, legal experts warn that this ruling would fundamentally reorient the landscape of federal liability, making governmental immunity the standard operating procedure for virtually all law enforcement errors, rather than the narrowly defined exception intended by congressional statute. This is what happens when constitutional rights collide with institutional self-protection. This bitter and protracted legal saga serves as a textbook example of the direct, unforgiving collision between the fundamental constitutional rights of citizens, specifically the right to be secure in one's home, and the powerful, relentless imperative of governmental institutions to protect their own agents and their internal power structures from public scrutiny and accountability. The Supreme Court spoke clearly, but the real test is whether lower courts will listen. The unanimous clarity provided by the Supreme Court's mandate was unmistakable, yet the true test of the judicial system's independence and integrity now rests with the lower appellate and district courts, which face intense pressure to either faithfully enforce the High Court's narrowing of immunity or yield to the government's powerful, sustained efforts to strategically circumvent that ruling. The government lost unanimously, yet the fight over accountability is escalating. In an unprecedented display of legal defiance, the federal government suffered a total defeat at the highest level, a 9-0 judgment against them. But instead of retreating or settling, their response has been to escalate the legal conflict, doubling down on highly technical immunity defenses, thereby intensifying the national debate over the limits of executive power and accountability. The outcome of this case could reshape how federal raids are judged nationwide. Pivotal to the future of federal law enforcement oversight, the eventual ruling in this case holds the potential to dramatically reshape the legal standards and judicial scrutiny applied to all federal paramilitary or no-knock raids conducted across the country, determining whether courts will demand meticulous execution or permit a wide margin for error under the guise of discretionary immunity. The DOJ claims no rule requires agents to verify the right house. Critics say that argument should alarm everyone. One of the most controversial elements of the Justice Department's defense is the assertion that no explicit, mandatory departmental rule compels federal agents to conduct a final verification that they are, in fact, entering the correct house before executing a warrant. A legal position that critics vehemently argue is not only indefensible, but should serve as a chilling alarm to every American citizen concerned with law enforcement standards. This legal battle asks whether federal power has real consequences when it devastates the wrong family. At its heart, this prolonged litigation is a profound moral and legal inquiry into whether the massive operational power wielded by the federal government carries commensurate consequences when it is mistakenly and devastatingly unleashed upon an innocent family, serving as a gauge for whether accountability remains a theoretical concept or a concrete reality in America. A unanimous ruling narrowed immunity. Now the DOJ is pushing the boundaries back open. The Supreme Court recently employed its authority to create a necessary limitation on the potentially limitless scope of government immunity, yet in a move of direct institutional opposition, the Department of Justice is actively working within the legal system to stretch those newly narrowed boundaries, aggressively attempting to return federal agents to a state of near absolute legal protection. If mistakes are labeled discretion, who is ever protected from federal error? If the courts accept the government's argument that critical errors, such as raiding the wrong address, can be legally categorized as protected discretionary functions, the practical consequence will be the evisceration of public protection, leaving no genuine legal avenue for victims of federal operational errors to seek justice or compensation. The courts must now decide whether wrong house raids are policy or plain negligence. The responsibility now falls heavily upon the appellate judiciary to make a crucial distinction whether a disastrously executed, wrong address federal raid constitutes an intentional policy choice protected from liability, or if it represents a clear and harmful lapse in professional duty that rises to the level of actionable negligence, requiring systemic accountability. This case could determine whether federal agents are answerable to the same laws as everyone else. Ultimately, the outcome of this fiercely contested case will serve as a defining moment in American jurisprudence, establishing whether federal law enforcement personnel operate under a unique, virtually untouchable standard of immunity, or whether they must ultimately be answerable to the same fundamental legal standards of care and conduct that apply to all other members of society. The Supreme Court said, "Accountability matters. Now the system has to prove it meant it." Following the powerful statement from the Supreme Court emphasizing the importance of accountability for federal misconduct, the entire judicial and executive system is now under intense scrutiny to demonstrate whether that principle is genuinely enforceable or if institutional forces can successfully obstruct justice, rendering the High Court's pronouncement merely symbolic.